It is a recent and somewhat disturbing phenomenon in today's courtroom. It's known as the CSI effect. It's raising the standard and burden of proof for prosecutors and the acquittal rate for likely guilty defendants all over America.
Many potential jurors expect real-life crime scenes to be portrayed just the way they always seem to be on TV, with cops arriving at a murder scene, finding the victim, and immediately starting to gather a treasure trove of evidence. They think detectives should be able to find the DNA and the fingerprints of the guilty party.
It's not how the real world works, and in lots of courtrooms where, for example, DNA doesn't appear, the prosecution doesn't come up with that magic little bit of forensic evidence, jurors say, well, then the guy must be not guilty, or at least we have reasonable doubt.
So is the so-called CSI effect to blame for the jury's shocking conclusion of reasonable doubt in the Casey Anthony trial? Joining me now with reaction, a forensic pathologist, Dr. Michael Hunter, and Fox News legal analyst Bob Massey is back with us. Guys, good to see you. Thank you. All right, thanks. Well, let me ask you, this is your business. You are a forensic pathologist.
Sure.
Do you think this is having an impact on juries? Are they expecting the DNA must be there or else they're not going to find guilt in a case?
Right. You know, I think being on a jury is extraordinarily difficult. That jury has a very tough decision to make. So they're going to expect the DNA or the bullet or the knife mark. You know, they want to see something that's substantial because they do look at CSI. They see these things coming about.
Let's tie it to this case. We don't know the cause of death. We don't know how she died.
Right.
We don't know how she got there. We don't know who did it.
Sure.
I know that the mother lied, acted bizarre, partying, 31 days not reporting it, total negligence on her part. Bob Massey, tell me where you tie that to murder as charged.
When you introduce experts, Sean, in forensics, as the prosecutor did, once you bring those experts to that courtroom, it is their job to tie the nexus to cause of death. You cannot, if experts on behalf of the district attorney cannot create the nexus on the elements you just said, you cannot go to that jury and say, you now become our expert. And that's essentially why they had a problem. They look to experts. They need to say, doctor, based upon a reasonable degree of medical probability, what was the cause of death? We don't know. You can't then go to the jury and say, you become our expert. That is too much of a standard for 12 people to be asked to do, and that's why it failed.
I think that's extraordinarily well said. Michael, when the coroner cannot give a cause of death, it now opens it up to speculation. When you cannot put Casey anywhere near that scene or anywhere near any of the materials found around the scene, and and you also have your own experts contradicting it, and you're using a whole new area of forensic science that the state of Florida has never used before. Isn't it why aren't people seeing this as the stretch that it is?
You know, I think there's some issues that are a stretch. I mean, the chloroform, a stretch. The tape, saying that that's the instrument of the homicide, somewhat of a stretch. You know, this is a medical examiner case. I look at this as really dependent on the medical examiner looking at that jury and telling that jury what the cause of death is and what the manner of death is. And keep in mind that this medical examiner, the one for the prosecution, never actually went to the degree that the prosecution wanted. They wanted to go with premeditation. They wanted to go with obstruction of the airway because of the placement of the tape. Now, she wasn't going to go there. She basically built, I think, a very strong argument for homicide. But as far as the other issues, the issues of premeditation that the jury would want to see, the medical examiner's not even going there.
Yeah, and you know, Bob, one of the things, and it's funny because I'm reading very thoughtful emails. I'm not getting mean emails from people, very thoughtful. And people are trying to give me that 5% that I keep asking for. Because after the lie about the nanny-zanny, after the lie about working at Universal, after the lie about the rich boyfriend, after the 31 days, you know, no DNA on the duct tape, no cause of death, nothing to tie her to this. The timeline on the smell in the car was so bad for the prosecution because literally they're giving us people smelling it 5 days before a whole list of people that didn't smell it. And
you know, Sean, I'm sorry.
Yeah.
You know what impressed me with Baez, on his closing? I've always been a belief, I do the civil side law, that a picture's worth 1,000 words. When he put those posters up there, and he had the people about who smelled and who didn't, and then he just took them off one at a time. And then you had 6 other photos of some law enforcement that said they didn't smell. And let me tell you what he did that I thought was interesting. Everybody was wondering, but why did he leave George Anthony's picture up there? Because he didn't want the jury to forget that George Anthony, whether it be true or not, was a player. It was a brilliant, tactical, demonstrative evidence. And if you look at the DA's closing, they didn't use a lot of demonstrative evidence. They brought out the blanket.
But Bob, the DA had the prosecutors had the last word. And after that, and they even got the benefit of having an entire night to respond to the close of Baez and the other attorney. And here's the point. You're right. They laid it out, and it was perfect. And then they went up there the next day and said, "We don't need posters." Like, yeah,
Sean,
you do.
May I say one more thing real quick? I thought it took a lot of guts. I've tried civil cases. It took a lot of guts, knowing the judge was going to come down on him, Baez to say that guy, and that laughing guy over there. That was a great to be. I'm going to tell you why. Because now you got 12 people sitting in a jury box, and they see a smirk on this DA's face. And, you know, sometimes people think, hey, buddy, don't take us for granted. Get that smirk off your face.
But he also did it very cleverly, I think, in case they needed an appeal. In all likelihood, a judge wouldn't be watching the tape. He needed that on the record, which was brilliant.
Absolutely.
Look, I still think we may find out one day she's responsible, and that would be heartbreaking. Right. But I think our rule of law and our Constitution and that integrity, I keep saying this, is far more important, even if we get it wrong occasionally. Guys, good to see you.
That's right.
Yeah. And in 18 minutes, we're going to see Greta Van Susteren, who's given us a sneak peek. All right, what's on the record?
I had no idea you were a member of the defense bar, the criminal defense bar. I'm
a member of the U.S. Constitution-loving, presumption of innocent team.
You know what? I'm so proud of you, Sean, because, we defense lawyers get so much trouble about when we talk about those constitutional rights in the courtroom. But anyway, so thank you very much. Anyway, tonight we're going to do a full hour. We're going to talk about the Casey Anthony trial, but we have one guest, Sean, I think you'll be particularly interested in. That's a man who was a roommate of Casey Anthony in June of 2008, and that's the month when supposedly the child had disappeared. So the roommate will tell us an awful lot about what Casey was like that month of June.
All right, Greta, we won't miss a second. Thanks for the preview, and let not your heart be troubled. Our great American panel is next.